Then see 46. Out of the 5 incidents, page 789, running page 177. Out of the 5 incidents which constitute the right to establish and administer an education institution as noted in para 50, the right to admit student was not being considered to be an absolute or unqualified right. The decision in Namdar shows that in professional education institutions or those imparting higher education, merit-based selection can be taken in the interest of nation and subserving and strengthening the national welfare. This one will not apply to us because we are dealing with schools, primary education. Then selection of meritorious students have been accepted to be in the national interest. A minority institution cannot, in the name of the right of 30, disregard merit, etc. as regards professional and higher education. The right to take disciplinary action against the staff has also not been accepted as an unqualified right. TMA-5 Foundation lays down that even in unaided minority education institutions, a mechanism must be evolved and appropriate tribunals must be constituted to consider the grievance. Until then, the tribunal could be presided by a judicial officer, etc. To that extent, there is a definite departure from the law laid down in Ahmedabad, which struck down 51 and 52A of the Gujarat University Act, then 47. When it comes to the right to appoint teachers, in terms of the law laid down in TMA-5, a regulation framed in the national interest must necessarily apply to all institutions, regardless of whether they are run by majority or minority, as the essence of 30 is to ensure equal treatment between majority and minority. An objection can certainly be raised if an unfavorable treatment is meted out to an educational institution established and administered by minority. But if ensuring of excellence in educational institutions is the underlying principle behind a regulatory regime, and the mechanism of selection of teachers is so designed to achieve excellence in institutions, the matter may stand on a completely different footing. The test accepted in TMA-5 Foundation and the balance between the two objectives can well be considered in the context of two categories. One, imparting education which is directly aimed at or dealing with preservation and protection of heritage, culture, script and special characteristics of a religious or linguistic minority. While the second category of institutions can be those which are imparting what is commonly known as secular education. When it comes to institutions of the former category, the teachers who believe in the religious ideology or in the special characteristics of the minority concerned would alone be able to imbibe in the students admitted in such institutions what the minorities would like to preserve, profess and propagate. But if the subject in the curriculum was purely secular in character, that is to say subjects like arithmetic, etc., the intent was to impart education availing the best possible teachers. In the first category, maximum latitude may be given to the management of the minority institutions concerned, as they would normally be considered to be the best judges of what would help them in protecting and preserving the heritage, culture and script or special features of the minorities. However, when it comes to the second category of institutions, the governing criteria must be to see to it that the most conducive atmosphere is put into place where the institution achieves excellence and imparts the best possible education. Then note 50, if your lordship sees. Thus, if intent is to achieve excellence in education, would it be enough if the educational qualifications were to employ teachers with minimum requisite qualifications, while better qualified teachers are available to impart the same education? Well, then it goes on to say something which I don't need to go to, Lord. That is, it can even go beyond laying down minimum standards. But minimum standards, Lord, is something which can be laid down equally for majority and minority institutions. Then, Lord, the statutory provisions are specifically considered and upheld. The main substance of my submission is that it is now absolutely well settled that regulation of the qualifications to become a teacher in an institution will be the same for majority and minority institutions, and by insisting on that, you will not be violating Article 30. Section 23 of the RTE only deals with that. So, my lord, the line of authority which Pramati Educational, my lord, represents speaks about, my lord, reservations of 25% in schools admissions. There, my lord, they are excluding it for minority institutions. But when it comes to appointment of teachers and the standards that they have to maintain, it is completely settled, my lord, that such a section would be constitutional. So, my lord, section 23 is certainly constitutional if Pramati and Rajasthan are taken to mean that 23 has been struck down. Then in my respectful submission, my lord, it is completely per incurium. It ignores everything from TMFI Foundation and downwards.
Yes.
So this leads us, my lord, finally to two possibilities only. In my respectful submission, my lord, there are two possibilities open to your lordships now. Either, my lord, to harmonize Pramati and Rajasthan with the TMFI Foundation line,
Yes.
which means, my lord, your lordships will say that on a point of interpretation, these are only dealing with section 12 and saying that 12 will not apply to minority institutions. That's one possibility.
Yes.
The second possibility is that it has not considered section 23 in the light of all the judgments of this honorable court, so therefore it must be referred out. If your lordships are not, my lord, going to read down Pramati, then it should be referred to a larger bench, my lord, to consider the impact of TMFI Foundation and all other judgments in that area to section 23. The compulsion. The right to education.
Could you please read out 5C, answer to question 5C
Yes.
in TMFI concept?
Yes. TMFI is also in this compilation. 797. It can be
905.
sorry, Millard?
905. Volume 2.
Volume 2 of the compilation. Yes, Millard, that's the second volume. No, that is the beginning. We want 5C now.
5C, the answer to the question
Yes,
you will find at 905.
yes. 5C. 5C, Millard, the question is whether the statutory provisions which regulate the facets of administration, like control over educational agencies, control over governing bodies, conditions of affiliation, including recognition withdrawal, and appointment of staff, employees, teachers, and principals, including their service conditions and regulation of fees, would interfere with the right to administer minorities. Then answer. So far as statutory provisions regulating the facets of administration are concerned, in case of an unaided minority educational institution, the regulatory measures of control should be minimal and the condition of recognition as well as the condition of affiliation to a university or board have to be complied with. But in the matter of day-to-day management like appointment of staff, etc., the management should have the freedom and there should not be any external controlling agency. However, a rational procedure for selection of teaching staff and for taking disciplinary action has to be evolved by the management itself. For redressing the grievances of employees of aided and unaided institutions who are subjected to punishment or termination of service, mechanism will have to be evolved. In our opinion, appropriate tribunals could be constituted. Until then, such tribunals should be presided over by judicial officer. State and other controlling can always prescribe minimum qualifications, experience, and other conditions bearing on the merit of an individual for being appointed as a teacher or a principal of any educational institutions.
This observation is not diluted in
Any judgment. It is followed all the way. There are at least 6 judgments, Lord, which is following this. Brahmo Samaj, etc., etc. Malankara, everything is following it. This is the proposition, my lord, which would make 23 constitutional and which has not been taken into account in Pramati because they were only concerned with the reservation section. Section 23.
But viewed in the light of answer to question 5C,
yes,
Placitum F,
yes,
the management should have the freedom,
yes,
and there should not be any external controlling agency.
Yes. But minimum qualifications is allowed. Yes.
To be.
I'm not commenting on that. I'm not commenting. I'm saying that I'm satisfied with the minimum qualifications aspect. These are minimum qualifications.
And that you say the last paragraph.
Last paragraph is explicit. Explicit.
And you also further say that since 23 was not really the bone of contention in Pramati,
yes,
therefore the bench may not have adverted to this part of
yes,
TMFI.
yes. It has not taken into consideration this entire line of authority because it was not concerned with. So we will not read the judgment in that sense. But if your lordships have any hesitation, then will not refer it. Yeah.
place the majority view in AME, where Chief Justice Chandrachud upheld the order passed in 1981,
Yes.
whereby a two-judge bench referred it to a larger bench above 5,
Yes.
and that was held to be valid.
That is on the question of whether it is a minority.
Whether a two-judge bench.
No, I'm not. Your Lordship, follow Milord, the normal procedure. You can refer, Milord. This is a. This.
No, because if we refer it to 3 will again here.
Yes.
3 will send it to 5 will again here, and then it goes to 7.
Yes, Milord. If that is the procedure, Milord, I'm not asking.
But a departure is there in 8.
Suraj test by Davudi. In Davudi Bora
is the normal thing.
In Davudi
2
Bora,
to 3, 3 to 5.
No. Exceptions are carved out with Davudi, which says that if two judges feel that under 145(3) it's a interpretation of the Constitution of importance, then your lordships will place it before the administrative judge, who will then decide, and your lordship will say, we feel 5 or 7 must take a look.
So therefore, it has to go before the Chief Justice on the administrative side to decide whether it should go or not. But directly, a judge bench cannot say that a matter be placed before a 7-judge bench, because the 2 judges, this is the view that I have taken in AMU.
Yes.
You cannot.
Yes.
You have a 2-judge bench.
a different view.
Now, Yavati is 5. We cannot say that the matter should go before a 7-judge bench directly. This is what 81 said. That it should be placed before bench strength higher than the 5-judge in Aziz Basha. That has found favor with the majority. But Dawoodi Bohra never says that. Dawoodi Bohra says, in an appropriate case where a 2-judge bench feels that the matter should be considered by a 7-judge bench, because it does not agree with a 5-judge bench, it has to go to the CJI.
So,
CJI will take a call. We cannot directly send it.
if your lordships don't
If
your lordships don't mind my impertinence, that is of course the law.
that is why we are saying.
But
That is why
we
we are saying.
Jindal, your lordship sent it directly to 9 despite 7 sitting in the way. Directly from 5. In Aadhar, when the Aadhar bench was constituted, overnight it was sent to 9 despite the 7 and 8 sitting in the way. So it's not that the court follows this practice, even though there should be a practice which we follow. I'm telling you lordship what is happening actually. So despite this,
two judges, Justice Chauhan has referred the matter to straight away to the 9 judges bench. It is 2012-13 SEC. 2012-13 SEC, page number 490.
Volume
13.
2013.
2012,
2012.
volume 13,
Volume 30.
page number 497 minutes.
Is it that? We place the matter before the CJI.
It's true.
That is different.
But it can be mirrored.
We cannot straight away. If we follow Dawoodi Bohra in letter and spirit, it can only be a 2-judge saying let it be placed before 3 to 5, and then 5 takes a call.
But here we have 2 to 9 straight away.
No, 2 to 9. In between, it has to go to Chief Justice.
Always
Chief Justice may refuse.
but in every case, my lord, not
Chief Justice may refuse. This has followed from 1965, Justice Gajendra Gankar's judgment. It may so happen that a single judge is shown a direct judgment of a division bench covering the issue. Now, that division bench may not have considered a Supreme Court judgment on similar or slightly distinct issue. What is the course open to a single judge? He is bound by the law of precedence. Division bench is directly on the point. He has to follow division bench. But he finds that there is a Supreme Court judgment which, if had been taken into consideration by the division bench, the outcome could have been different. Justice Gajendra Garkar says, in such a situation, it would not be open for the single judge to say that no, division bench has not considered Supreme Court, I am not bound. I will follow Supreme Court. You can't do that. That is against rules of propriety. What he can do is, he will note both the decisions and say why he is not agreeable with the DB judgment. Then send it to the Chief Justice. And the call has to be taken by the Chief Justice. Here, come to para 14.
Yes, madam.
After recording all these, in view of the above, we place the matter before the Chief Justice for direction, not before a 9-judge bench.
Every case, my lord, even Lordship is referring any matter to even 3 judges bench. It will go before the Chief Justice, my lord.
Before is also a civil decision.
No, there is only a small distinction is there, my lord. Whether Lordship can refer to larger bench or 2, 3 judges or 5 judges or 9 judges. So the reference, my lord, which has been for 9 judges.
If we as judges of the Supreme Court feel that we are also bound by 141, then we have to follow the outcome. And if you feel that we are above 141, it's only for the High Court, then the situation is absolutely different. But anyway, Mr. Gupta is referring to this question 5C and its answer. Whether this was considered in Pramati has to be seen.
Lordship has to take.
And what would be the...
And my lord, if the second option is what your lordships are going for, I have no, my lord, I am not pressing for any one particular point of view. Referring to, my lord, a larger bench, but that's all.
Because the 3 judges bench also said that.
But therefore, the lordship is only referring it to a larger bench. The same problem is there in that judgment. In that judgment also focuses entirely on reservation, nothing else. And also doesn't talk about TMA 5 when it comes to, my lord, minimum standards to be maintained for appointment of teachers.
Very well. This is so
Now,
far as the
yes,
minority.
this is so far as minorities.
Promotion part.
Yes, the promotion part, my lord. First, come back to, my lord, the section. Section is 23 of the Right to Education.
I'm sorry because your lordship were on that point. I have the order of the 5 judges in Puttaswamy, which is the Aadhaar challenge. It's 2 sentences where they say this question of whether there's a fundamental right to privacy would entail a reconsideration of MP Sharma, which is by an 8-judge constitutional bench, and also correcting by a 6-judge constitutional bench. Before dealing with the matter any further, we are of the view that the issue noticed above herein deserves to be placed before the 9-judge constitutional bench. Consistent with what your lordship observed, that may not have been permissible on the judicial side, but that's what they've done. They should have ideally sent it to the administrative side, but because I think the Chief Justice was sitting on this bench, as the Chief Justice then was sitting in the general bench, they do it as practice, but classically that's inconsistent with the Dawoodi.
Now, the next proposition is this. After a particular date, which is specified in a notification, there is no doubt that in order to enter or be appointed as a teacher, you need TET. You need the TET qualification. The High Court has also said that those who are appointed teachers prior to that date, that is 29th of July 2011, do not have to have TET in order to enter the service. But it puts an embargo on them being promoted any further by saying that, and it says so not explicitly, that a promotion is also an appointment. And so therefore, every time there is a promotion, if you do not have the TET qualification, there is only one TET qualification. You don't have to get it many times. If you have it, then you can be promoted further upwards. If you do not have it, then for the time being, you cannot be promoted at all till you have obtained the TET. Now, it is our submission, my lord, that on a correct interpretation of section 23, the TET is only necessary at the point of entering the service as a teacher and not to other levels. So for that purpose, my lord, I go back to section 23. No, don't go there. At first, This, in my respectful submission, is a question of interpretation of section 23. So, my lord, I take your lordship first to the section itself once. Section 23 of the Right to Education Act. Qualification, my lord, it is at page 23 of the compilation, but your lordships, of course, are looking at it from the BRTE Act, certainly. Qualification for appointment and terms and conditions of service of teachers. Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Now, my lord, there is no dispute that the central government by notification has authorized the National Council for Teaching Education, NCTE, to be the academic authority mentioned in section 23. There is no confusion on that. Number two, there is no doubt that NCTE has in fact by notification laid down conditions. But along with this act, a small amendment was also made to the NCTE Act to permit it to lay down minimum qualifications. I will show that in the context of the third notification. So under this section, it is my submission that eligible for appointment as a teacher means eligible for first appointment as a teacher or initial appointment as a teacher. Matter of interpretation. First or initial appointment as teacher. Yes. So the stress bullet is eligible on the word eligible for appointment as a teacher. Now, in order to aid the construction that I am arguing in favor of, I would first draw your lordship's attention to the distinction which exists between appointment and an appointment by promotion.
Teacher is not defined.
Sorry, teacher is not defined.
Subsection 2, the provision.
Yes, I'll read. Yes. Let's place the whole section.
Yes.
No doubt.
Yes.
Since we are interpreting. Where I'll place 2 now. Where a state does not have adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualification as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment for such period not exceeding 5 years as may be specified in that notification. So that was done, but less than 5 years. And the proviso that a teacher who at the commencement of this act does not possess minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years, provided further that every teacher appointed or in position as on 31st of March 2015 who does not possess minimum qualification as laid down in subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement.
If you continue on the same post of teacher, you are required to obtain this qualification.
Depends, my lord, on the interpretation of 23(1).
No, even if see, read 2 once again.
Yes.
It says that
initial and
future situations.
yes,
That on and from this date, when the act is enforced,
yes,
if you are aspiring for the post of a teacher, you need to have the minimum qualification.
that's good.
One is with regard to future appointments. Two is with regard to appointments which have already been made.
Not two, proviso. Two says that this date can be pushed back forward.
Yes. Two. Proviso is to two.
Now,
First proviso,
yes,
provided that a teacher who at the commencement of this act
yes,
does not possess, as laid down under subsection 1,
yes.
shall acquire such qualification within a
So
period.
this is effectively, my lord, a proviso to one itself.
So therefore, leave aside promotion for the time being.
Yes,
I am a teacher in a school. I don't have the TET qualification.
yes,
In terms of the proviso, I am required to qualify in the TET
yes.
within a particular.
No, no. My submission is no. And in fact, in practice also no. No state has said that if you are appointed prior to 29th of July 2011,
Please come to proviso once again. Let us read it.
no, I'll read it. No difficult. Provided that a teacher who at the commencement of this act does not possess minimum qualifications as laid down under subsection 1.
What does this mean? Who is in position as a teacher without the qualifications mentioned in 23(1)
Yes,
has to possess these qualifications within a period of 5 years.
yes. Shall acquire such
Yes,
minimum.
may I clarify this? Lord, this is in subsection 2, they have said that, Lord, even after the coming into force of the RTE Act, Lord, if there is a difficulty faced by any state, where, Lord, if your Lordships will kindly see, Lord, 23 subsection 2 in totality, it says where a state does not have adequate institutions offering courses or training in teacher education or teachers possessing minimum qualifications as laid down in under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher. This is to take care of the immediate contingency, because after the coming into force of the RTE Act, immediately we did not even know what exactly TET meant. So, in order to take care of the initial teething problems, if we have to still appoint, there were some states in the northeast, etc., where they were not having even facilities to train teachers for the teacher eligibility test. If such teachers are brought in after the coming into force of this act without TET, though TET is a qualification, then, the proviso comes into play to say that they will acquire it. They will be appointed without TET even after the act. However, they can acquire this within a period of 5 years, which was also extended to 4 years. So the proviso is to 2, not to 1.
No, proviso.
Here, the state has to answer one
A
thing.
teacher who is on the date of commencement of the act not possessing the minimum qualifications for him,
Yes.
time is given. Initially it was 5 years, then another
4
1 year
years.
plus 4 years, 10 years.
In fact,
Yes.
in fact,
It was given.
no, my lord, in
But
fact,
here, if the state says only
It is
this,
not that those who were in position as teachers have been kept outside the coverage of 23(1).
that your lord, the way that your lordship is putting it to us, my lord, is that every teacher at the end of 5 years must have TET.
That seems to be the intent of this statute.
No, my lord, subject to correction.
Time of this.
Subject to correction. Because, my lord, that means that even if you are in the service, 10 years before this act came into force, you will still have to get TET.
that can be
No
clarified
state-
in
no
para
state
4A.
has proceeded on that basis. Even the High Court judgment, my lord, says that you can continue to occupy your position in the entry post without TET.
There could be a reason. HCT could throw some light.
Yes,
Lord, NCT para
That
5A
is
explains.
Personal experience.
yes.
Lord, but the state has to
Okay, sir.
explain.
To move a motion before PIL bench in Calcutta High Court
Yes.
in 2005. Nobody knew about NCTE Act. All the training institutions were awarding degrees without being recognized by the NCT. The Calcutta High Court held that if your institution is not recognized by the NCT, this is only a paper degree. Now, it could be so that the NCT, while laying down the qualifications, might have found that most of the institutions which have granted these training degrees were not recognized by us. and on that basis they have been appointed. So NCT may have insisted that after this act has come into force on 2009, irrespective of whether you have obtained a training degree from a recognized or an unrecognized institute, you need to qualify in TET examination.
Yes, please. Consider one other possibility. The act comes into effect, but because there are no TET exams being held at all in that stage,
So 5 years.
so therefore I take teachers, and those teachers will have to, they have become teachers, but they will have to take it within 5 years.
Provided that a teacher who at the commencement of this act
Yes.
does not possess. Who is that teacher?
Correct. All the roles in service.
Who is that teacher? That teacher is the in-service teacher.
Yes, my lord. But
So you are referring to somebody who is to be taken immediately after the act comes into force, but there
no,
are
I'm not.
you will have to give some meaning to these words. A teacher who at the commencement of this act
Yes.
does not possess.
So therefore
That
he has
is
to
a
be in
teacher
service.
that in service.
So we are not dealing with, my lord, such persons, my lord. We are,
No, you're dealing with this. When you say for promotion, you don't require TET, you're mentioning.
You're a teacher who
That's,
can
in fact, the state has filed an appeal against the order of the division bench saying that those in service can continue. The senior
even
council
the
will
High
have
Court
to
holds
explain
so.
that. No, the state government has filed appeals not only against the issue of promotion, they also say that they filed several appeals against the proposition that those who had been appointed prior to 29/7/2011 can continue in service. That's what the bench said. That may be right or wrong, but the state has now filed an appeal against that. But Lord, Mr. Gupta is arguing that Lord, they can continue. But there
Yes.
seems to be some contradiction there.
my lord,
No, that's okay. That is it.
itself has, there is a notification. And the NCT itself has not taken the meaning like this, that 23, the serving people have to continue, because they have provided in the notification, they have provided two categories, for the people who are recruited and for promotion. And for promotion, they themselves have not said that TET is mandatory. That's it.
Madam, that's
You have
it.
to argue that.
Madam, you have to interpret the statutory intent from the what NCT understands of the act. We can only say God bless them. We can't say anything more than that. Yes, if they have not understood what the act says, then good luck to them. No wonder we are in the situation that we are in. If the regulator doesn't understand the act.
Volume 3, which I had printed up, and at page 184, the MHRD's letter, which interprets why they brought in this 23-2 proviso. Page 184. That volume